tomorrow morning, Parliament suddenly passed a law that completely removed elections from India. Seriously, just think about it. Or what if you woke up to find that your fundamental rights were secretly destroyed overnight? No free speech, no right to life, gone. Sounds like a terrifying movie plot, right? But the reality is, the power to pass laws is absolutely immense. Without the right defenses, our democracy could easily slip into tyranny. Today, we are opening the vault. We're going to look at the ultimate weapons of the Supreme Court. Let's get right into it.
You know, if politicians had absolute unchecked power, our Constitution would have collapsed decades ago. But it hasn't. Why? Because of something I like to call the rescue. It's this secret intellectual arsenal forged by Supreme Court judges over decades to protect our democracy. They didn't use armies to fight, they used ideas. And these ideas form the absolute boundaries that no government can ever cross. So what exactly are these weapons? We call these weapons constitutional doctrines. Now, if you're wondering what a doctrine actually is, think of it like a highly advanced, unbreakable antivirus program installed in your computer. The Constitution? That's the operating system of India. Whenever the government tries to download a dictatorial virus or pass a toxic law, these doctrines instantly detect the threat, block the virus, and protect the whole system. Pretty cool, right? Let's dive into the first set of these protections and see how they form the unbreakable walls of our democracy.
Part 1. Pillars of Democracy. The absolute boundaries of power. Let's take a look. We're starting with the foundational pillars. First up is the Basic Structure Doctrine, linked directly to Article 368. Back in 1973, in the legendary Keshavananda Bharti case, a massive 13-judge bench stood up like a shield against Parliament. Parliament effectively said, hey, we have the power to amend anything, and the Supreme Court replied, listen, you can change the walls, but you absolutely cannot touch the foundation. Certain fundamental features, like democracy, secularism, and judicial review, simply cannot be altered. It's the ultimate veto. Alongside this, we have the Doctrine of Separation of Powers, highlighted in the 1975 Indira Narhan Dandi case. This doctrine enforces a strict rule. The Prime Minister, the Parliament, and the courts must stay in their own lanes. The legislature makes the laws, the executive applies them, and the judiciary checks them. Simple as that. Nobody gets to be a king.
Part 2. Protecting fundamental rights. Your shield against tyranny.
Now, imagine this situation. The government passes a massive 100-page law. 90 pages are great for the country, but 10 pages completely crush your personal freedoms under Part 3 of the Constitution. What happens then? Do we just throw away the whole law? Well, here is where the Supreme Court gets surgical. First, the Doctrine of Severability, linked to Article 13 and the 1957 RMD Chamar-Bagwala case. It's exactly like finding a rotten spot on a perfectly good apple. You don't throw away the whole apple, right? You just cut out the rotten part. The court removes the invalid sections of a law and keeps the rest intact. Next is the Doctrine of Eclipse from the 1955 Bikaji Narang case. Think of a solar eclipse where a shadow temporarily covers the sun. If a pre-Constitution law violates your fundamental rights, it doesn't die entirely. It just goes to sleep. It becomes dormant, covered by the shadow of your rights. And finally, the Doctrine of Waiver from the Behram Khurshid case. This one is absolutely crucial. You cannot voluntarily throw away your fundamental rights. They are your constitutional armor, and the law simply won't let you strip yourself of that protection, even if you want to. No way.
Moving right along to Part 3, the power struggle, center versus state battlegrounds.
Welcome to the high-stakes political thriller arena. The Constitution divides power between the central government in Delhi and the state governments. But let's be real. Politicians are power-hungry. They constantly try to cross their borders and steal power from each other. So how does the Supreme Court referee this heavyweight match? Well, if you're an AIBE aspirant or a law student, here is your ultimate memory trick. First, the doctrine of colorable legislation from the KC Gajrabati case. The rule is super simple. What cannot be done directly cannot be done indirectly. You can't sneak in through the back door. If a state doesn't have the power to tax something, they can't just disguise it as a fee and pass it anyway. On the flip side, we have pith and substance from the FN Balsara case. Sometimes laws accidentally overlap. A state law might slightly touch a central subject. Here, the court uses pith and substance literally like an X-ray machine to find the sar tattva, the true essence or soul of the law. If its true nature actually belongs to the state list, the law survives, even if it slightly touches the center's territory.
But what happens when there is a direct collision? Enter the Doctrine of Repugnancy under Article 254. Imagine a heavyweight boxing match in the concurrent list. That's the area where both center and state can make laws. If a state law directly contradicts essential law, the parliament basically delivers the knockout punch. The parliamentary law prevails, and the state law becomes void to the extent of the conflict. Then we have territorial nexus from the Chalmers-Bakwala case. Look, a state can only make laws for its own territory. It can't cast its fishing net into another state's waters unless it can prove a real, tangible connection, a nexus, between the object it wants to tax or regulate and its own state borders. Makes sense, right?
Okay, part 4. Expanding legal horizons, adapting to the future.
We've seen how the court stops tyranny, protects rights, and referees the center-state fight. But, the Constitution is a living, breathing document. It has internal paradoxes, and it has to constantly prepare for the future. Let's see how judges brilliantly solve these complex puzzles. Sometimes, two parts of the Constitution itself seem to be at war with each other. That's exactly where harmonious construction comes in, established in the Venkaramana Devarro case. It's kind of like a parent grabbing two fighting siblings, sitting them down and forcing them to shake hands and coexist. The court interprets conflicting provisions so that both survive. They harmonize them. And then there's incidental or ancillary powers, from the G. Chawla case. Honestly, this is pure common sense. If the Constitution gives Parliament the power to buy a car, it automatically gives them the power to take the keys. If you have the authority to legislate on a main subject, you automatically get the power to legislate on matters closely connected to it, just to make the main law actually work. As we look to the future, the court uses two pretty brilliant tools. First, prospective overruling, introduced in the famous 1967 Golok-Nath case under Article 141. When the Supreme Court changes its mind and sets a completely new legal rule, it obviously doesn't want to create a time travel paradox that destroys thousands of old, closed cases. So they just say the new rule will only apply prospectively, meaning from today onwards. The past stays completely safe. Finally, the doctrine of legitimate expectation, rooted in Article 14's equality principle, as seen in the Navjoti co-op case. This one is all about trust. If the government has a long-standing practice or makes a promise, citizens legitimately expect them to keep it. The government cannot just arbitrarily change the rules overnight without giving you a fair hearing.
We've covered a massive arsenal today, from the absolute shield of the basic structure to the surgical precision of severability. What you really need to take away from this explainer is that without these doctrines, our rights would just be ink on a piece of paper. Constitution सिर्फ एक किताब नहीं है, ये इंडिया की democratic soul है. The Constitution isn't just a book, it literally is the democratic soul of India, kept alive, breathing, and fighting by these very principles. So the next time you see a politician signing a new bill in the news, remember the invisible walls waiting for them in the courtroom. Thanks for joining me on this deep dive. Keep questioning, keep learning, and I'll see you next time.